Hello everybody, my name is Martin Jarrett and I am a Senior Research Fellow at the Max Planck Institute for Comparative Public Law and International Law. Let me dive straight into my presentation here with the problem that I'm interested in. Imagine we're in the context of an investment treaty arbitration. The investor's claim looks like a good one. The state, however, and of course, wants to defeat it, and it has a weapon for this purpose. An argument that the arbitral tribunal lacks jurisdiction because the investment was procured with corruption. If the state succeeds, the investor's claim is dead. If you're an investor, what can you do to overcome this weapon? Now, your initial reaction might be simply to dispute the fact of corruption, and perhaps this is a good tactic. In this video, however, I want to introduce you to another strategy, hence the title, A Strategy for Defeating Objections to Jurisdiction Based on Investment Establishment Illegality. Give me about 12 minutes and I'll tell you what the strategy is. Let me dive a little bit deeper into the problem first by referring to an example. Imagine our investment is an apartment complex. This apartment complex is half complete. And now the investor turns its attention to getting all of the permits that it needs to make sure that people can eventually move into these apartments when they are finished. It encounters a government department in that process which is absolutely plagued with corruption because the officials within that department always ask for bribes, and the investor is not an exception to this. The investor does not want to pay the bribe, but it decides that it has to pay up to make sure that it can complete the investment. Now, years later, the investor brings a good investment treaty claim in respect of another matter. At the jurisdiction stage, the state says, one of our conditions to arbitration is that the investment must be lawfully established. This investment was procured with corruption. Corruption is unlawful. Therefore, this condition is not satisfied. The result is we have not consented to arbitration, and therefore the arbitral tribunal lacks jurisdiction. So we run into a pretty familiar problem here in the jurisprudence of international investment law. An otherwise meritorious claim is destroyed by corruption. Now, there's a big debate regarding the fairness of that outcome. I don't want to deal with that debate here. I want to rather put myself in the shoes of the investor. I want to imagine that the state's evidence of corruption is overwhelming. In that moment, can I do anything or am I done for? That is the challenge that I want to deal with. Here's a solution that I've been thinking about. I think there's some potential to use the doctrine of duress. So if the state argues that an arbitration agreement between it and the investor is invalid because the investment legality requirement is not satisfied on account of the investor's participation in corruption, then the investor can say this: that act of participating in the corruption was the product of duress. As the product of duress, it has no legal effect, meaning that the arbitration agreement cannot be invalidated on this ground. Now, in order to give that argument wings, I need to prove 4 premises, which are, first, duress is applicable to arbitration agreements. Second, the doctrine of duress is temporally applicable to the relevant acts of duress, that is, the act of the government official. 3, the doctrine of duress can be used in this way to resurrect an otherwise invalid arbitration agreement. And 4, the acts that the investor says forced it to pay the bribe can actually amount to duress. Or put in another way, the investor's participation in corruption can be described as the product of duress. I think that the first of these premises is fairly uncontroversial, so I'm not going to deal with it. The next 3, however, premise 2, 3, and 4, need further attention. So let's go to premise 2. Question here is this one, you can see there. Does the doctrine of duress reach back so far to the point when the corrupt dealing between the investor and the government official is taking place. The thing you really have to note here is that this corrupt dealing will happen well before the formation of the arbitration agreement between the investor and the state. So there's two ways to go about trying to answer this question. First one, you can argue that the doctrine of duress applies pre-formation of an arbitration agreement, and there is authority for that view, i.e. that the doctrine of duress applies to parties pre-contractual arrangements or pre-contractual conduct towards one another. What, however, happens if that argument doesn't get up? I've thought about a second argument here, which is a little complex, and I'll need a full slide to properly go through it. The basic idea is what you can see on the screen there. The arbitration agreement has already been formed at the time of corruption. In order to validate that conclusion, I need to prove another three premises here. First one will be controversial. Investor-state arbitration agreements are unilateral contracts. You can definitely contest that, but just remember, a unilateral contract is simply a contract formed by a promise and an act. So if we think about this and we talk about arbitration agreements between states and investors, we can think that the state's offer of arbitration agreement in a treaty is a promise to arbitrate in case of a dispute with an investor, and then the investor can perfect that arbitration agreement with an act, namely its act of making an investment in the host state, and in the event of a dispute, initiating arbitration. So because you have on the one hand a promise and an act, I think you can describe these investor-state arbitration agreements as unilateral contracts. Second premise, less controversial. Unilateral contracts form when the promisee, which is in our case the investor, starts performing. Third premise is the investor starts performing when it makes its investment within the host state, because that is the first concrete step towards perfecting the arbitration agreement between the investor and the state. I'd be really interested to hear anyone's thoughts on this line of reasoning. If you see any problems, or if you have praise, I'd be very interested to hear your comments. Let's move along now to the third premise. Core question is up on the screen there. Can the doctrine of duress be used to nullify states' jurisdictional objections? Specifically, can duress be used to block the state's argument that the investor has failed to satisfy the investment legality requirement? Now, the problem here is that duress, as far as I know, has not been used for this purpose. So traditionally, duress is used to avoid contracts, that is to argue that a contract should not bind a person because his or her consent to the contract was vitiated by duress, or it can be it can be used to avoid a change to a contract. So, for example, imagine that there is a contract between two parties, and one party uses illegitimate force to change the terms of that contract by pressuring the other counterparty. That is also a situation where the doctrine of duress can be used to restore the original terms. Now, if you were, for example, counsel for the investor, and you were challenged something to the effect that the doctrine of duress cannot be used in this way, I think your best argument is to really emphasize that the doctrine is a fairly flexible tool, and it should be used to ensure that the making, changing, or terminating of contracts are all acts that are consensual. And that's where I think this argument really goes, because it's really saying that the investor was illegitimately forced to invalidate the arbitration agreement, meaning that such invalidation should not be recognised, which leads very nicely into the fourth premise here on the substance of duress. Core question is, could investors' participation in corruption ever be called the product of duress, or could it ever amount to being the product of duress? There are three substantive elements of duress. First one is that one there, an illegitimate threat. Second one is that this threat causes the investor to act or participate in the corrupt dealing. If we think about the apartment complex that I spoke about earlier, I think both of these elements are satisfied. The third element, however, presents the real problem. There must be no reasonable alternative for the investor other than to participate. You can imagine there are plenty of arguments that could play out on this element. I don't have the time to go through all of them, but you can think, on the one hand, the investor could be told there is always an alternative. Go to investment treaty arbitration and complain about the solicitation of the bribe. On the other hand, the investor will say this alternative is not reasonable because it's too costly, it's potentially ineffective. Now, interestingly, when I was conducting the research for the paper that this presentation is based on, I found some case law to the effect that the alternative of going to court and complaining about duress is not always reasonable. So that there's a small glimmer of hope there for an investor. So that's the theory. I really make these videos to hear your thoughts on them, so please share them with me. Just before I go, I do need to note down some limitations. The first one is the theory is really limited to situations involving systemic corruption. Second one, when I spoke about the doctrine of duress, I'm referring to the doctrine of duress as it exists in English law. And third and finally, there's the outstanding issue of sanctioning investors' participation in systemic corruption. I don't want to create the impression that this conduct is not wrongful. My thoughts are rather that it should be dealt with in a different way, which is actually something I'm working on right now, and soon enough I'll publish a paper on how arbitral tribunals for investment treaty arbitrations can better sanction investors' participation in corruption. For now, however, I'd be interested to hear your thoughts on the work that I've just presented. So, many thanks for listening.